The glittering facade of modern celebrity often masks a much darker and more turbulent reality that transpires behind closed doors, far from the flashing cameras and the adoring crowds. For decades, the public has been captivated by the grand narratives of royalty and fame, watching from a distance as historical lineages intertwine with contemporary media culture. Yet, beneath the polished exterior of public appearances and carefully orchestrated press releases lies an ongoing and bitter struggle for personal autonomy, privacy, and truth. It is a conflict that has simmered for years beneath the surface of British society, pitting some of the most prominent figures in the world against the formidable institutions of the mass media. This complex relationship between public interest and private life has gradually evolved into a high-stakes psychological war, where every headline is a weapon and every court appearance becomes a definitive historical battleground. The stakes could not be higher, as the fundamental definitions of personal dignity, freedom of information, and the accountability of powerful organizations are weighed in the balance of public opinion and legal scrutiny. To truly understand the gravity of the latest shocking developments that have sent shockwaves through the global community, one must first peel back the layers of a decades-long saga defined by intense scrutiny, unyielding pursuit of justice, and a profound sense of institutional betrayal. If you want to stay informed about these unfolding historical events and receive deeply researched, analytical breakdowns of the stories shaping our world, please consider subscribing to the channel now and turning on all notifications so you never miss a crucial update. The narrative that is currently unfolding in London is not merely a localized legal dispute, but rather a critical turning point that challenges our collective understanding of how justice operates when ordinary citizens and global icons alike attempt to hold the most powerful media conglomerates accountable for their actions. To fully grasp the immense tension surrounding the current moment, we must journey back to an era when the landscape of media consumption was undergoing a radical and aggressive transformation. Throughout the late 20th century and into the early decades of the 21st century, the relentless demand for intimate details regarding the lives of high-profile individuals created a fiercely competitive environment among major news organizations. The boundaries of ethical journalism began to blur as the race for exclusive stories intensified, leading to allegations of increasingly desperate and clandestine methods used to breach the inner sanctums of private citizens, public figures, and members of the royal family itself. For many years, these allegations, whispered in the corridors of power and discussed in hushed tones by media insiders, remained largely unproven or were dismissed as mere conspiracy theories manufactured by disgruntled individuals. However, as time progressed, the whispers grew into a deafening roar as specific evidence began to emerge, suggesting that the methods employed by certain elements of the press extended far beyond traditional investigative reporting. It is within this atmosphere of deep-seated suspicion and long-standing resentment that a coalition of determined individuals decided that silence was no longer an option. They chose to step forward out of the shadows of their private grief and public obligations to challenge the very architecture of the media establishment, initiating a legal crusade that many observers believed would permanently rewrite the rules of engagement between the press and the public. At the very heart of this dramatic confrontation stands a prince who has spent his entire life under the unyielding and often cruel glare of the global spotlight. From the tragic moments of his youth, through his years of dedicated military service as a helicopter pilot, and into his eventual transition into global philanthropy, his existence has been documented, dissected, and commercialized by a voracious media apparatus. This lifelong immersion in the public eye has fostered a profound and deeply personal understanding of the devastating impact that intrusive journalism can have on individual lives, mental health, and family stability. Having witnessed firsthand the profound challenges faced by his late mother and later seeing his wife subjected to what he described as absolute misery under a constant invasion of privacy, the prince reached a definitive breaking point. His determination to seek accountability became not just a personal quest, but a broader crusade to protect others from experiencing a similar fate. joining forces with an eclectic group of prominent public figures, including a deeply respected activist and legislator who has spent decades fighting for institutional accountability following her own profound family tragedy. The claimants formed an unprecedented alliance. Together, they represented a diverse cross-section of society united by a shared conviction that no organization, regardless of its wealth, influence, or cultural dominance, should be permitted to operate above the law or manipulate public perception through allegedly unlawful means. The anticipation leading up to the recent judicial decision was palpable across the United Kingdom and around the globe as legal analysts and the general public eagerly awaited the outcome of a years-long legal battle. The claimants had presented what they believed to be a compelling and comprehensive mountain of evidence detailing intricate operations involving alleged listening devices hidden in vehicles and residences, private investigators, tracking movements, and the systematic interception of deeply personal data over a period stretching across multiple decades. The defense mounted by the powerful publishing house was equally unyielding, relying on steadfast denials and asserting that all information obtained for their widespread publications was sourced through entirely legitimate and conventional journalistic practices. As the High Court prepared to deliver its highly anticipated ruling, the tension reached a fever pitch, with many viewing the impending judgment as a definitive litmus test for the integrity of the judicial system and its capability to withstand the immense pressure of media influence. When the decision was finally handed down on a Tuesday morning, it did not bring the resolution or the sense of closure that many had anticipated. Instead, it sparked an immediate and explosive controversy that threatened to deepen the existing fractures between the public, the judiciary, and the press. The ruling, which dismissed the long-running lawsuit, sent immediate shockwaves through the legal community and elicited an unprecedentedly fierce response from the claimants who refused to accept the verdict in silence. The immediate aftermath of the court's decision witnessed a dramatic and highly public condemnation of the ruling by the prince and his fellow claimants, who took the extraordinary step of issuing a joint public statement that pulled no punches. They openly described the judgment as a complete and obvious whitewash, declaring that despite coming to the halls of justice seeking accountability, they had received absolutely nothing of the sort. The language utilized in their response was remarkably candid and filled with a profound sense of disillusionment, reflecting a belief that the court had applied an entirely different set of rules for the powerful media defense than it did for the individual claimants who had brought their grievances forward. They argued with immense passion that the court had chosen to uncritically accept the simple denials of journalists, while wholly ignoring parallel findings from other historical trials where similar unlawful activities by private investigators had been formally established. This perceived inconsistency was characterized by the prince and his allies as something completely hard to understand or reconcile with basic common sense, creating a narrative of a judicial system that had gone to shocking lengths to exonerate a massive publication. As this opening chapter of the legal drama concludes, the stage is set for a much deeper examination of the specific mechanics of the ruling, the intense psychological toll on those involved, and the profound wider implications this decision holds for the future of accountability and the freedom of the press in an increasingly complex digital world. The unexpected outcome of this high-stakes legal battle has pulled back the curtain on the intricate and often baffling mechanics of the judicial system, leaving legal experts and the general public scrambling to comprehend how such a massive volume of allegations could be dismissed so definitively. To understand the profound tension that characterized the courtroom during this lengthy trial, one must examine the specific assertions made by the Duke of Sussex and his fellow claimants against Associated Newspapers Limited, the powerful publisher behind some of the most widely read publications in the United Kingdom, including the Daily Mail and the Mail on Sunday. The core of the lawsuit, which was originally initiated back in 2022, was built upon a series of deeply unsettling claims that painted a picture of a relentless, coordinated campaign of surveillance and privacy invasion spanning from the late 1990s all the way through 2011. The claimants alleged that the media conglomerate did not merely rely on aggressive reporting, but actively crossed ethical and legal boundaries by employing private detectives to place sophisticated listening devices inside personal vehicles and private residences, unlawfully intercepting phone calls, and obtaining sensitive medical and financial data through illicit means. These were not casual accusations. They represented a direct challenge to the operational methods of one of the largest media networks in the world. And the details presented during the proceedings were intended to demonstrate a systematic pattern of wrongdoing that completely disregarded the basic human right to privacy. As the details of the trial emerged, the atmosphere grew increasingly charged with emotion and conflict, particularly when the prince took the stand to deliver his deeply personal testimony. He described in vivid detail the immense psychological burden that this perceived surveillance placed on his family, revealing that his wife, Meghan Markle, lived in absolute misery during her time in the United Kingdom due to the constant, unyielding invasion of privacy by the tabloid press. This domestic strain was compounded by a parallel battle over their personal safety, which reached a critical juncture when the family was denied taxpayer-funded security after stepping back from their official roles. The lack of institutional protection created a situation where the family felt uniquely vulnerable, leading to the highly publicized decision that the Duchess and their young children, Prince Archie and Princess Lilibet, would remain in the United States while the prince traveled alone to England. This logistical split highlighted the real-world consequences of the ongoing feud, transforming a complex legal dispute into a painful family drama that played out on the global stage. With the prince arriving in London under intense media scrutiny just days before the definitive judgment was scheduled to be delivered. The irony was not lost on observers that while the prince was in town to promote a global athletic foundation built on resilience and recovery, he was simultaneously facing an immense institutional wall in the Royal Courts of Justice. When Judge Matthew Nicklin finally delivered his comprehensive ruling on that historic Tuesday morning, it became immediately clear that the court's perspective on the matter differed fundamentally from that of the claimants. In his detailed summary, the judge acknowledged that the allegations brought forward by the Duke of Sussex and Baroness Doreen Lawrence were exceptionally serious and touched upon matters of significant public importance. However, the legal pivot that ultimately decided the fate of the lawsuit rested on the strict burden of proof required in civil litigation of this magnitude. The judge wrote that the claimants had simply not proven that the specific information used by the publishing company to craft its numerous articles over the years had been obtained through unlawful methods. In a crucial clarification that directly countered the core strategy of the legal team, the court rejected the argument that because certain information was inherently private, and because the publisher could not immediately or positively explain how it had been sourced, the relevant articles must therefore have been the result of illegal data gathering. This distinction effectively placed an immense evidentiary obstacle in front of the claimants, ruling that the mere suspicion of wrongdoing, combined with a lack of transparencies regarding journalistic sources, was insufficient to establish a definitive legal violation under existing British law. The reaction from the Prince and Baroness Lawrence to this judicial reasoning was swift, fierce, and entirely unprecedented in its willingness to directly challenge the authority and consistency of the High Court. In their explosive joint statement, they pointed out what they viewed as a massive and inexplicable contradiction between this ruling and previous judgments handed down in parallel phone hacking claims successfully brought against other major media entities, such as News Group newspapers and Mirror Group newspapers. They noted with immense bitterness that generic findings regarding various private investigators, who were held by the courts in those previous cases to have carried out widespread unlawful activities at the exact same time, were wholly ignored in this instance. Adding a layer of sharp irony to their public condemnation, the claimants explicitly mentioned that the very judge who made this latest decision had actually represented those rival media groups during the time when those past hacking claims were being successfully litigated. This connection led the prince and the activist to suggest that the court was demonstrating an inconsistency that was completely hard to understand or reconcile with common sense, creating an environment where it felt like there was one rule for the massive newspaper networks and an entirely different, much stricter rule for the individual claimants seeking accountability. This sense of institutional betrayal deepened as the claimants described the actual dynamics that unfolded inside the courtroom over the course of the long-running trial, alleging a fundamental imbalance in how evidence was weighed by the judiciary. They argued that while they had presented a mountain of compelling documents, witness statements, and contextual data to support their claims of illegal surveillance, the journalists and executives representing the Mail simply offered blanket denials. In the eyes of the prince and his allies, the court chose to uncritically believe those corporate denials, even when faced with what the claimants described as obvious contradictions, inconsistencies, and blatant untruths that were readily apparent to any neutral observer sitting in the room and comparing the testimony to the historical documents. This scathing assessment of the judicial process transformed the story from a standard corporate lawsuit into a profound debate about the very nature of truth and power within modern democratic institutions, raising uncomfortable questions about whether an individual, regardless of their status or resources, can truly find a level playing field when challenging a media empire that possesses the unique ability to shape public perception and defend its own interest with limitless legal resources. The timing of the ruling added a final, dramatic layer of contrast to an already intense day, as the prince was forced to pivot instantly from the devastating legal defeat to his public-facing international obligations. Just moments after learning that his years-long quest for legal accountability had been dismissed by the High Court, the Duke of Sussex had to compose himself and stand before an audience of international policy experts, diplomats, and military veterans at Chatham House. He was there to deliver a major welcome address at the 14th Invictus Games Foundation Conversation, a conference dedicated to translating international policy into practical support for wounded, injured, and sick service personnel. The sheer psychological resilience required to transition from a stinging personal and institutional rejection to a formal address on global leadership and recovery was evident to everyone in attendance. This moment served as a powerful testament to the complex, bifurcated life the prince now leads, where the bitter, unresolved conflicts of his past in the United Kingdom continually collide with his forward-looking efforts to build an independent, global legacy, leaving the public to wonder how this profound legal setback will alter his strategy moving forward as the narrative prepares to transition into its final, most analytical phase. To truly understand why this shocking judicial outcome carries such immense weight, one must examine the deep-seated motivations and biographies of the individuals who risked their public standings to bring this historic campaign to the steps of the High Court. This was never a mere disagreement over tabloid headlines. It was a deeply symbolic battle led by two figures from entirely different worlds, united by a profound sense of personal tragedy and an unyielding desire to challenge institutional power. Baroness Doreen Lawrence, now 73 years old, is one of the most revered civil rights activists in modern British history, having spent more than 3 decades fighting for justice following the racially motivated murder of her teenage son, Stephen Lawrence, in London back in 1993. Her tireless efforts over the years completely transformed the British legal landscape, eventually leading to a landmark public inquiry that exposed systemic institutional failures within the Metropolitan Police Force. For a figure of her immense moral authority and structural importance to join forces with the 41-year-old Duke of Sussex demonstrated that the concerns regarding the methods of the tabloid press extended far beyond the realm of celebrity gossip, reaching into the fundamental mechanics of how powerful organizations treat ordinary citizens during moments of profound vulnerability and grief. For the prince himself, this legal crusade represents the culmination of a lifelong struggle against an invasive media apparatus that he has long held responsible for the defining tragedies of his existence. From the chaotic events surrounding the untimely passing of his mother in Paris to the relentless media storm that enveloped his relationship with Meghan Markle. His adult life has been shaped by a persistent determination to rewrite the rules of engagement between public figures and the press. His autobiography, which offered unprecedented insight into the inner workings of the royal family and his personal battles with mental health, underscored the deep-seated nature of this conflict, detailing how the constant pressure of living under a media microscope can erode personal relationships and dismantle family units from the inside out. By choosing to pursue these claims through the formal structures of the judiciary rather than relying on standard public relations statements, the prince sought to establish a definitive legal precedent that would force media conglomerates to operate with greater transparency and ethical accountability, making the eventual dismissal of his case a particularly devastating blow to his broader life mission. The historical context of this dispute reveals a complex web of previous legal battles that makes the current ruling even more controversial and difficult for neutral observers to parse. In the years preceding this trial, the British media landscape had been repeatedly rocked by immense hacking scandals that resulted in the permanent closure of major publications, the imprisonment of prominent journalists, and the payment of millions of dollars in damages to hundreds of victims of unlawful information gathering. During those parallel proceedings, the courts formally established that private investigators had routinely utilized illegal methods to breach security systems, intercept communications, and gather private data on behalf of major news organizations. The fact that the High Court in this specific instance chose to view the evidence against Associated Newspapers Limited as insufficient, despite these well-documented historical precedents, highlights the unpredictable and highly technical nature of modern civil litigation, where the specific presentation of documentation and the strict allocation of the burden of proof can completely overshadow broader patterns of industry behavior. This definitive ruling carries profound implications for the future of journalism, public interest broadcasting, and the shifting boundaries of personal privacy in an increasingly complex digital age. By confirming that a publisher cannot be held legally liable simply because it cannot or will not explicitly reveal the exact journalistic sources of its private information, the court has effectively reinforced the traditional protections surrounding investigative reporting and confidential sourcing. Media advocates argue that this decision is a vital victory for the freedom of the press, ensuring that journalists can continue to investigate high-profile individuals without the constant fear of being forced to dismantle their investigative networks in a court of law. Conversely, privacy advocates and legal representatives for the claimants warn that this verdict could create a dangerous shield for unscrupulous organizations, making it exceedingly difficult for any individual to successfully challenge potentially illicit surveillance methods if the evidence remains locked within corporate archives or hidden behind a wall of blanket administrative denials. The fallout from this legal decision will undoubtedly reverberate throughout the institutional structures of the British media and the royal family for years to come, influencing how public figures navigate their relationships with the press and altering the strategic calculus of future privacy litigation. Despite this massive setback, the Prince and Baroness Lawrence concluded their explosive public intervention by expressing their deepest gratitude to their dedicated legal team and to the brave witnesses who were willing to step forward into the global spotlight in the pursuit of institutional justice. Their uncompromising stance suggests that while this specific legal chapter in London may have reached a definitive and frustrating conclusion, the broader global debate regarding media ethics, corporate accountability, and the inherent human right to a private life far away from the unyielding glare of the public eye is far from over, leaving an indelible mark on the historical record of modern cultural conflict.